Hello and welcome to this second part of my presentations. This day will be about commercialization of IP in general, about the economic and social impacts of such a phenomenon like commercialization of IP on the society. So if you remember in the very first part, we talked about different aspects of IP, as for example, about technical aspects. What is, for example, an IP right, or what are IP rights in general, or even what are they in particular? So, what is a patent? Then we talked about some practical aspects, as for example, how to search a patent. So a patent search is very practical, and we found out how to do it. On the other side, we learned about other practical aspects as how, for example, to apply for these IP rights in different legislations. There are possibilities of maybe international applications and so on. So these are also quite practical aspects. However, what we did not talk about, and that is in fact one of the very important part of the IP rights, was about actually the economic aspects of the IP rights. As you all know, in fact, the IP rights are very relevant economic tools. So most of your, uh, let's say, most of the people you are working with for the first time and so on, who are not involved in a daily basis with IP rights, might have also a false idea about the IP rights. So you hear a lot these false, or at least I hear a lot that type of false idea about IP. So now I have a patent, so where is the money? So people might think if they are not in this business that just by applying and even by being granted an IP right, the rest is done automatically. So once I have a patent, people want to have that patent and I will earn money. In the real world, things are quite different. In fact, you know it better than I. Things are not going like that. So you have to invest money, and this investment is actually justified only if you have some return on investment in return. So, in fact, applying or even having a patent are only costs. They do not bring automatically some money with themselves. So if you want to earn some money from that patent, of course, you have to do something, and that is not that important. However, uh, this aspect is, of course, is a very, very important, and so we will to try to talk about different ways of seeing the commercialization aspects of IP. So uh, the whole day, the whole block is divided into four parts. In in the first part, I'm going to talk about the commercialization for startup and spin-offs. I will talk about how, in fact, the commercialization of IP rights affect the economic situation of, for example, European countries. All the European countries, the countries of European Union, as well as Switzerland, for example. So I will try to demonstrate how IP commercialization affect in a positive way, in that I can tell it now, a positive way, the economy of those countries. And then we will see actually how it can be done, and how we can actually make some effort to do it, that this commercialization is facilitated for people dealing with IP. In order to do that, and that is the second part of these block, we are going to talk about enabling conditions of technology transfer. We know that the technology transfer is a very important part of IP commercialization. Especially nowadays, it is one of the very important aspects of nowadays IP strategies. And how can we somehow do our contribution in order to help people by enabling the conditions of technology transfer? I will talk during these parts also about different types of contracts, but uh, then in the third part, I will be more specific, and I will talk about different types of contracts and agreements that might be necessary in the whole process of technology transfer up until the commercialization, of course, of the IP right. Of course, when we are thinking of technology transfer, we think at the same moment about license agreements and license contracts. However, license and licensing is not the only contract type which we meet during that process. And one thing we want to emphasize during this block is that we have to think of what type of agreements might be important for us. Then I will end the whole with one experience we had, that is the Swiss experience, and the whole thing will be somehow quite yeah, let's say rounded up with that sort of story. It is storytelling about the story we experienced in our country. So, once talking about enabling conditions of technology transfer, it is important for me that you know that the solutions I might somehow emphasize there, and I might tell you about them, are not, in fact, a solution for everybody at every situation. What is important for me is that you understand that this solution is just one solution among many others. Uh, in fact, that is the way we are doing it in Switzerland. It is as easy as that. It is just an example how it can be done for a country which has the situation of Switzerland with all possibilities and or disabilities of that country. Uh, it might not be the right solution for you, and I'm sure it is not the right solution for you, but the idea is actually to learn about how people might do it, and that might give you an idea of how you do it better. Uh, in a way which is adapted to the environment you are working in. And as we as we talked about the IP rights, I mentioned that the IP rights are, in fact, are in sort of territorial rights, so they are always adapted to the territorial situation. So the implementation of the whole thing, also the implementation of commercialization or enabling condition of technology transfer shall be, of course, territorial. So that is just a way which it can be done among a lot of them, and that shall give you an idea about your own way of doing things. Then, in the when we are talking about the contracts, we will talk about the whole procedure, and we will actually see that in the whole procedure of IP commercialization or even just technology transfer, there are different steps, and you never start at the beginning with the last, let's say, contract, which is licensing contract. But each step might need some agreement. So what are those agreements? What type of contracts and agreements might be interesting for which type of, let's say, interactions? And then what are the traps and tricks? What are, let's say, specific possibilities or specific difficulties that might happen during those transactions, and which are the points we shall be careful about when we are dealing with contracts or with different agreements. So that is actually what is it about when we are talking about the contracts. In the last part, I will talk about the Swiss experience. That is, in fact, an experience we had while legislating about the Swiss-made designation. So we will see actually how we lived all that experience. And I thought that might be actually a good ending for everything in order to demonstrate how these enabling conditions and environment can also come, and what is the contribution of a government, the legislator, to facilitate also the IP value and IP commercialization, or at least assure how it can assure in that case a certain added value. So this protection of Swiss made designation is, to my knowledge, one of the first time we see it in the world. So it might be also quite interesting from that aspect. In fact, before that, we had always an IP right, which is called geographical indications, which is quite known also in your country. But geographical indication is normally just from a region. Here in that case, in fact, it is about a whole country. So when am I allowed to use the Swiss flag? When am I allowed to use the designation made in Switzerland and so on and so forth? And that is now legislated in our country, and that is actually, I thought, at least it would be a good ending to the whole content. Then, of course, there are two other parts that together with these four presentation will complete the whole day. One is about IP strategy, and the other one will be about IP valuation. Let's say we are going to talk now about actually what is IP from Swiss and European perspective. or IP commercialization, what does it bring, let's say, for the Swiss society or for the European society in general. Um, we are all somehow convinced that IP has a positive effect on our, let's say, society and on our way of life. But is it really like that or not? That shall be studied and shown. It is not just by saying it is good, it is an incentive that is enough. Uh, are there any indications that is like that? um, let's I'm a patent examiner, so I'm living with the IP rights, if you want. So I'm living from IP rights. So I have the right even to be a real hard defendant of IP rights, but that is not what I'm here to say. What I want to say is, in fact, you can also imagine a society without IP rights, and that can even function quite good. So, are there any real benefits from IP rights? Yes or no? We will go through, let's say, the studies which have been done to see how much of the legend is correct and how far it goes with IP rights. Then, what are the factors that enable IP? So just to have an IP, but having an IP does not mean that you are successful. That means actually we have the IP, but to be successful, we need more. Then, how to treat technical knowledge, and then, of course, which IP strategies should I choose in order to be successful at the end? I had in the strategy part a lot of these discussions. We will see it again here somehow, and you will refine those aspects also here. The whole is, of course, based on an attempt to create an added value through also one of the IP rights, and these added value through an IP rights. That is the case of Swissness that will round up the whole block. You will see these comes in fact just through the indication of a source. Mm, In that case, the Swissness, it means actually the source of production, maybe that is in Switzerland. And that is in fact an added value by itself, and it can be an added value by itself. So we will also see that special case in detail. So I told you that a lot of times since people talked about IP rights. IP rights existed around the world since more than 200 years ago. So there are more than 200 years ago people talking about IP rights and how actually benefit there are for the human beings. The truth is, in fact, that is not provable. We cannot prove that IP rights are quite beneficial, yes or not. There are some let's say some justice um, feelings that might be the reason of some of the IP rights. As for example, the copyright, the right of an author for his work, so that nobody else can actually uh, give the work of an author to his name. That is a bit more about justice than anything else. Or the right of an inventor on his technical invention. Uh, um, but are they really and economically necessary for a society or not? That has not been studied so long. So what happened is, in fact, the European IPO, that is the Intellectual Property Office of the European Union, decided to make a study in order to find out what is the impact of intellectual property rights on the economy of European Union. So these are actually what they found for their studies. One was conducted in 2008, 2010, and the other one between 2011 and 2013. One of the first findings were that how big is the value of intellectual property in Europe? In other words, how do trademarks, designs, patents, copyrights, geographical indications contribute to employment, to gross domestic product, GDP, to the remuneration, and to the trade? Is it true that, for example, if you are working for an IP R intensive company, you earn more money, for example? That is about the remuneration. Uh, so they in fact wanted to somehow demonstrate what is the effect of it without being somehow biased by other aspects. So that was actually the very first European Union wide study on the value of the intellectual property right. And this time, actually, I choose the word value because now we are talking about the value in the sense as we have seen in the valuation part. It is actually what is somehow subjectively important for the European Union, but also is objectified in a manner that it is comprehensible for third parties. So that was the value they wanted to estimate. So first thing they found out was that there are about 321 IPR intensive industries, uh, and almost none of them is actually, or not so much of them are only IPR intensive in just one of the IP rights. For example, uh, you can find maybe, I don't know, some, yes, from the 277, let's say, trademark intensive companies out there, there is just a small part of it which is only very intensive in trademarks without having other, let's say, aspects of IP rights. From, for example, a total of 140 uh, patent intensive companies, there are only 16, which is actually about 10% of them, are only patenting without using any trademarks, design, or else. So uh, that shows that how interrelated these IPRs are. In fact, once you are actually using a patent, uh, you, most of the time you might have a product, and when you want to sell the product, not only the patent is important, but also actually your reputation on the market. So you have actually a trademark somehow there. So you need that trademark. And then if it is about a product, about a finished product, then this product might have a form, and the form of this product is also protectable by a design. So then you have actually not only the, let's say, a trademark, but also a design. Even actually the patent related things are more and more correlated with the copyright related things. I'm thinking about actually about computer implemented inventions where you have softwares that have some technical effects, and these technical effects being new, inventive, and so on can be patented. So these are also actually quite interrelated. From the 4GI, these are actually geographical indication intensive industries. Almost none of them is actually only in GI. So you have those that are at least active in design or most of them have been also active in trademarks. So you see the interreliability and interplay between different IP rights there. Then they estimated, in fact, the value, if you want, in money and also in the total share of the contribution of IPR intensive industries to the GDP. And they found out that actually quite a big amount of money is out there, which is generated by these type of industry. So, for example, alone the trademark intensive industry has a total share of 35.9% of the whole GDP of European Union, which is actually quite a huge amount. It's more than one third of the GDP is generated through the trademark intensive, let's say, companies. So if you see then this also design intensive and then the patent intensive, copyright intensive, and also all other aspects as like GI and so on, you come to the numbers you can find about there is more than 5.6 let's say milliards in euro. If you see that the total EU GDP is at about some let's say just a little bit more than twice as these amounts, then you will see how actually hard it is to neglect that industry. So of course they did not do the error to just sum up the values they found there, because we said there are interplays. So companies who are active in trademark, they're also active maybe in patent and so on and so forth. So actually the figures you find out here is not just a sum of what you find just beforehand, but they also took into account the interplay between different IP rights. So that was actually the part which was just by hard numbers and so on. So I mean, it is good to have that much amount of money in the hand of industry, but does it bring something for people living in European Union? Yes or not? Because I mean, that is the amount of money that the industry may have as profit or as money, but that does not mean that it is actually redistributed one to one or in a certain form for people living there. So they also uh, took this example to find out what is the percentage of European Union jobs which were directly or indirectly generated by these industries. And they did it actually twice, once in the period of 2008 2010, and the second one was actually in the period of 2011 2013, in order to see actually also if that changed into one or the other manner. So they found out that in the very first study in the period of 2008 2010, there was one fourth of all European jobs, European Union jobs, are directly generated by these IPR intensive industries. And about 9% of them are somehow generated by in industries which are indirectly involved in to supply goods and services for those IPR intensive companies. So all in all, you're at about 35% of the jobs in European Union. Again, one third from every three, let's say, job place, one of them, more than one of them, is directly or indirectly created by or was created because it's 2008, 2010, and it was created at that time by, let's say, IP are intensive industries. So also you can see how the distribution is there. Then, for example, about 20% is related to trademark, 10% to patents, about 12% to design, and so on and so forth. So these are actually the figures they found. So it's not that bad, I would say. Actually, a one third, knowing that lots of jobs uh, out there are not cannot be related maybe directly to IPR intensive companies. And I mean, our daily shopping and so on and so forth, and people working for that are, or for example, teacher and so on, universities, all our works, if you want, administration and so on, are not among them. So you have actually lots of those jobs which are created somehow else, but still one third of all jobs are related to IPR. Then they have redone the same study in order to find out, uh, is it actually some effect which increases in the time or it decreases. And for the next period they did the same. They found that in fact uh, there was an increase of even some 3 more percent. So this time they found out that 28% of the jobs were directly created by IPR, let's say, um, intensive industries, and about 10%, additional 10% was let's say, due to industries which supply goods and services for the IPR intensive industry. So uh, that is 38% of, let's say, all EU jobs. That is a huge amount of person are somehow living from that. In number, in total number, something about 82 million people are living in European Union, thank to not thank, but also actually in direction or in relation with that type of industry. So uh, it is again a big number, but not only that it is a big number and that is impressioning, impressive, that is enough. It is, of course, if you look at it in the number of, let's say, persons involved, it is something like actually the whole population of one of the biggest countries in Europe, from the number of population, which is Germany. So about 80 million of people are living directly or indirectly from those type of industry. That means, in fact, okay, so they are contributing economically uh, to the job market of European Union, which is a good news for European Union having these force and having actually the possibility to profit from their own intellectual property rights. So, and the point is again, jobs are not equal jobs, because there are jobs which are better paid and less paid. So I mean, what if actually those people are all working for those industries and they're really paid very, very poorly? So, I mean, then again, it is not meaning having so many jobs, okay, that gives the possibility to people that they can work and they can actually prosper. But that does not mean that actually, okay, just by having that possibility, everything is done and yeah, it's good. We are good now. No. Again, another question which was very important is actually, are they well remunerated? And if you look at the numbers they found, you see actually they are in all aspects, in all IP related aspects, they are better paid, and by far better paid as the let's say non-IPR intensive industries, let's say in a sort of middle. Uh, of course, it's not quite comparable uh, because the jobs are not exactly the same, but for the same qualification you can make some comparison. The comparison was done between people working for different companies, different type of let's say income effects, and then which have the same qualification. There are, I don't know, they did actually more or less the same sort of the sort of let's say education. They're living in the same countries, same regions, and so on. And that it comes out that, for example, for people working in patent intensive companies, they're earning about 64% more than their colleagues in non IP are intensive companies. Of course, for the case of programmers and so on, where you have copyright, it is even better. That is about more 69%, 70% more what they can earn as for the other one. So they are not all only contributing to the pure number, they are also, these jobs are also contributing to the wealth of the people. So that was actually what they wanted to show and what came out of this study. So IPR is of course the tool. It is the legal tool, but this legal tool, if you use it correctly and if you use it actually in a strategic way, that would bring you not only let's say some sort of protection, but more than that, that will bring you some economic wealth. And then, of course, again, not only actually that there are about 20, that was the study in year 2008, 2010, that the number of, let's say, employment directly related to these type of industry by 26%, and you can see actually which are the countries which are more or less in that case. So you have countries above average. Here you can say actually Italy, Germany, Great Britain, Sweden, for example, and so on. And there are, let's say, countries which are somehow it's under the average or below the average, like for example France, Spain, and so on. These are also, of course, the countries that live a lot also out of their other assets. France, for example, Spain, also even I can tell country like Netherlands, they have a lot of agricultural aspects and products. So they have actually a big part of their GDP coming from agriculture, which is not directly maybe related with the IPR intensive part. So uh, again, just shows that you can also live in a country with like Sweden, where it is too cold maybe to have your own agriculture through other assets, as here is the case with IPR related. Then, of course, when you translate it to GDP, about 39% of the GDP in the European Union is generated and again, most of those countries we have seen before are in the case that they are somehow earning above EU average and some a bit less. Here, for example, United Kingdom, in fact, which was quite uh, above average when it was about the job number. When it comes to actually to the GDP, is under average. So what we find out at the end is not that we can say yes, IPR is good and IPR can be actually the solution for everything. Uh, what we can actually state here in this stage is that IPR can be useful. That is, for example, an example which can be seen where IPR helped the whole region of European Union in order to solve part of their problems, economic problems, and give them the wealth what they have. So if you look at the heart of the Europe, there is a country just in the middle, and it is not blue or dark blue. That is actually Switzerland. So, as you might know, Switzerland is not part of the European Union. So, the question remains, how about Switzerland? Are we in the same case? Can we tell exactly the same thing? And what is, in fact, actually the effect of IP rights for Switzerland? So unfortunately or fortunately, we did not do the same study, so I cannot give you exactly the same, let's say, results and, which was done in the European Union. But what we did, in fact, is actually to investigate about the funding and performing of R&D in Switzerland due to sectors and in fact to find out who is investing money in R&D and who is performing in fact the R&D for the money which is actually invested. So you see actually of course big part of the R&D fundings are coming from the private sector, and you have actually the federal government, which makes a quite big contribution also to that. I told you Switzerland somehow a bit different country, uh, similar maybe to the United States from the whole where they have the states and federal government. We have also the federal government, and instead of states, there are cantons. So the cantons are also actually paying the amount of money for the for the resources of research and development. The same goes also for universities to less extent, and also the when I talk about abroad, that is actually all other countries outside Switzerland, which also make some funding, some investment in the research and development in Switzerland. So now, when you come to these, actually, the sum of these, let's say, money, you find about 18.5 million francs. It's more or less the same in US dollars, so about 18.7 US dollars. That is the whole money which is invested in R&D, and that is redistributed in different sectors as well. So big part of it is redistributed in private sector, but universities are even very important there. So they are doing actually some good research and development, let's say, work there. Also, federal government and other actors are doing that, and you will see that actually in the investigation and funding, let's say, comparison. Actually, Swiss actors are investing netto more money in the let's say in the in other countries than the other side. So it's about 2.2 million investment from outside into Switzerland, and then you have on the other way actually about 3.3 million, which is actually is invested in foreign, let's say, R&D actors. So in all that, it was not taken into account the Swiss the affiliate of Swiss companies abroad. So Nestle, for example, has a lot of actually affiliate companies all over the world. What we actually took into account was only Nestle Switzerland as for the private sector, for example, in Switzerland. Then uh, good to know also actually which industries are somehow at the heart of, let's say, investments in Switzerland. Nowadays, I have to say that the biggest part is, of course, in biotech. Then healthcare, IT, and medtech is altogether the next big part. Then you have the ICT, fintech, and the rest of it is actually among other actors. So you see, in fact, the biotech is especially in last years, become more and more important, having a lot of people eager to invest in that. What is actually we see at least during the years of 2018 2020 was also growth in fintech, that is financial technology, so and ICT. So these are somehow the hottest topics that are coming, and I cannot see that, for example, healthcare and medtech would diminish also, because I think actually these are very very important aspects of which are of most importance for all of us, our health and actually the possibilities to use technology to somehow improve our health situation. So as we all know, everything starts with a simple idea. So once you have the idea, when you have the knowledge, uh, let's go step by step in order to make that somehow in a sort of analytical way, how the whole process can be done. So the first question you might ask yourself when you are inside such a system is that, for example, uh, is there any knowledge available in the company? So there shall be an idea, there shall be a knowledge that is available in the company. So we cannot, of course, do that based on something comes from outside. So once the question is actually answered with a yes, then you can go and proceed to the next step. So does have this knowledge a commercial use, or does have this knowledge uh, the potential of a commercial use? Uh, that is actually one of the questions you might be affronted when you are in the case of a technology transfer officer in the university. So it will be nice that the people, your researchers, when they come to you, that they have an idea of the application of the industrial application of that idea, of the feasibility and so on. But that might be also part of your duty. So to think if there is something, what is the market? What would be the best market you can imagine, and so on. So is there any commercial use? Then the next step would be, in fact, so now how can we actually uh, make use of that, let's say, commercial use? Shall we use a contractual or a non-contractual appropriation? So these are both possible. Let's think about, for example, a software. So the software might have a commercial use. So there is actually both possibilities. You keep it secret, you use just identical, I don't know, executables and so on, and you just give away the executables, but you keep actually somehow the knowledge, or you try to make a software out of it, and then you try to license it. So that is a contractual situation or with a non-contractual situation. Both is possible, both is acceptable. And then the question rise up if the knowledge is of a technical nature. And by technical nature is a quite difficult question, even if it is so easy. Sometimes, okay, it is, you can see it just directly. That is actually something technical. If it is about, let's say, some object, if it is some about some device, and the whole device is new, of course it is of technical nature. Nowadays, we do have a lot to do with other types of solutions and knowledge, which are not directly a device. But as I told you, maybe that is just a software. However, just a software does not mean that there is no technical nature in it. So even actually, there are softwares that have or that may produce a technical effect. So, in fact, again, the technical nature of the effect of that software might be interesting for further investigation. So, one very proper question is actually, is there any technical, let's say, nature? And if not, you might find other ways of how to exploit that idea. You won't go further maybe for a patent, but that does not mean that it cannot be exploited at all. You might have other ways of exploitation, as I told you, contractual, non-contractual solutions, like, for example, the software licenses, or even actually other solutions, non-contractual solutions, for example, for that appropriation. Then the next step would be, in fact, if that is a technical solution, if the knowledge has a, let's say, a technical nature. So the next step would be, in fact, uh, does the knowledge describe, or is the knowledge somehow described in the state of the art? That means then there you might need a search. So again, you see, actually the whole training was thought to be actually a whole. We come back to the very first step we did actually. It is the search part. So you need maybe that search. So is it somewhere in the state of the art? Is this knowledge somehow known by any publication? Then, or for example, is the knowledge publicly known, or maybe it is just secret? So maybe actually somebody has this idea already, but he kept it secret. Of course, we cannot see that. What we can see is what is already publicly known. So that is a question at least you can answer with yes or no for the part are already publicly known. If it is possible, we have seen that actually there is almost not possible to do an exhaustive, let's say, search in the available knowledge. But at least you can set aside the trivial part. So by a simple search that you already know how to do it now, by now you are quite ready to do that type of search. So you know that to do yourself, or make do the search by somebody else. So once, in fact, you decided that it is not publicly known, at least not clearly can be deduced that is publicly known, then stay still, you might have two possibilities. Shall I use it as a secrecy, or do I want to make it public use? So that might depend strongly on many factors. The answer to this question is quite, let's say, easy and difficult at the same time. People say, in fact, if you cannot hide something, so go for an IP right and hide it if you can hide it. So keep it secret if it is actually doable, or go for an IP right where it is not doable. Good. Okay. So, but what can be kept secret, what cannot? That is a huge question, and the answer to that is not that trivial. Let's say, for example, if you are dealing with some, let's say, device, some the idea, the knowledge is related to let's say, a mechanical device, and the whole knowledge is actually just in the production of that device and in the device itself. Okay, so first, in the case of the producing that object, you might have a knowledge which allows you to make it more efficiently. And these knowledge, actually, the knowledge that is necessary in order to produce that mechanical device, is something which cannot be seen on the device itself afterwards. So that is, for example, let's say a method of production which is much more efficient. People cannot see how you produce that thing just by looking at that device at the end, if it is done by this way or by the other way. So it is not that easy to find out how it was done just by reverse engineering. In that case, yeah, that is something that can be secret, kept secret, because of course, it is not very easy to find out how it's done. If the knowledge concerns the product itself, so the mechanical device we are talking about, so most of the time, as soon as actually you sell the very first part or the very first product, yeah, people can open it and can see how it works. So reverse engineering could be a very useful tool in that case to find out what is your advantage. And that is, in fact, a case where keeping secret might not be quite easy. But I assure you, there are even mechanical devices that are so complicated that even the time you might invest to get the time and the money you might invest in order to make the re-engineering is so high that even that can be kept by secret. So in very complicated mechanical even watches and so on, that might be quite a reasonable solution. So the question, shall I keep it secret or shall I register a property right or property rights, shall be answered due to different, let's say, factors. And these factors, I tried to put them together in order to give you at least a hint in which direction you might go by keeping it secret, or maybe, let's say, by asking or applying for a property right. So these are, for example, some arguments that are pro-registration. So once you have a property right, you can use the blocking function of that property right against third parties. Which is in fact not possible for something which is kept secret. You cannot keep something secret and at the same time prohibit parties using it commercially. So if somebody finds out by himself how that secrecy works, you cannot actually block him doing that because you were the first one you found out how to go. That is the decision you have to make at the beginning. Yes for property right or no. Once you decide that no for property right, the blocking function is no more there. So the other thing is actually also having, let's say, a registered IP right is also a very good tool of advertising. It is, of course, not thought to be that, but people are using it and using it quite successfully. So, patented case, you see it almost on every packet or every new, let's say, innovation you see you can buy. Which does not mean anything, in fact, in that situation. A patented case, it means actually, hey, they got a patent on that. So what? So there's a patent on that. That does not mean it's better or less good or anything. But it is somehow quite an argument when you are in front of the public. A patented case means, yes, that is something patented, that is something new and inventive in that. So there is an innovation. Okay, people are seeing mostly that part. So that is actually an advertising function, which is actually quite reasonably used for the registration favorized handling. Then, of course, the finance function. There is actually also finance function of IP rights. There are a lot of actually provisions in different countries where, for example, your patent boxes and so on might even give you some exemption from taxes and so on. So then you have a stabilization and safety function of the patent. Once you have the exclusivity, that gives you a sort of safety which the other actors don't have. So you have actually this possibility to do it as only one because it's your exclusivity, and other people shall ask to at least a license, or even actually shall be afraid of eventually enforcement of your rights. Then it is the incentive function uh, shows that actually you have some more incentive in order to do more innovation and so on. And of course, for most of the let's say indicators which we know, they take into account the number of patents, the number of IP rights you have, and that is a performance indicator for most of actually also financial institutions. That is something which is quite non and also well used. On the other side, there are arguments against registration. Registration is just cost. Once you have the registration, you have nothing except the cost. Of course, you have the exclusivity and so on, but you have actually to use it. In order to use it, you have to enforce your right. In order to enforce your right, again, you have to invest. So the investing again money in enforcing your rights it means also a sort of not maybe losing money, but at least actually investing some money in the hope that you get something back. Uh, by an enforcement, you are never sure that you win. At the end, you might even lose. So you invest money and you can lose everything. So these are actually there are uncertainties that go together with a registration even. Then something against registration is once actually the invention is public, people actually have seen it and so on. So there is no more novelty. You don't need actually to go for registration. And then maybe in fact something against registration is actually by registration. You give away the knowledge so everybody else knows what you are doing, and that might be an indication for your competitors that you are probably infringing third party industrial property rights. So it is, in fact, your own patent might be a good hint for everybody else to see, okay, they are doing that and these, and that is too close to what I do. So they might really, in fact, infringe my existing patent, my existing IP rights. Another thing against registration is the publication effect of the IP rights. So once it is, let's say, registered, it is public to everybody. You have, in fact, an IP right in a country, or in some countries, in as many countries as you paid for, but you have given away the knowledge uh, to the world, to the, let's say, actually to the to the to the to the, at least actually everybody, to everybody who has access to internet, almost, so that is really all over the world, in every country. Everybody would have seen, or could have seen, your solution, because it is published. So everybody knows how it goes. Everybody can use it in the countries where you don't have the IP rights for free. So you give away these knowledge to everybody else for free. You just would have it only in some countries. Then, uh, uh, so what are the, why shall I keep it secret? Of course, you don't have the cost for a registration, and as long as you keep it secret, it is secret. So you have lowered the cost. No actually application, let's say, cost, no enforcement rights of rights cost, and anything. So the cost factor is going in your sentence. However, it is not that easy. It is not actually free of charge, because even keeping secret means that there are some regulation. You cannot just keep something secret and say that is my secret. You have to show that it was your secret. So you have to also take reasonable steps to keep it secret. And once you are in front of a judge, the judge will ask you, what are the reasonable steps you have taken to keep it secret? And these might also demand some cost. So you have actually to bind people longer to you. You have to distribute the knowledge so that not one person goes away with the whole knowledge. So you have other types of cost, but that is maybe a bit less than in the case of registration. Then, of course, in that case, in fact, you know that once you did an invention, you asked for the IP right, it will be published and everybody knows it. In the case of secrecy, there is no publication, so nobody knows it. As long as nobody actually has access or has found by himself the secret knowledge, it remains secret. Then people cannot know what you are doing, so it is much more difficult to find out if you are infringing third party patents or not. Of course, once they are suspicious, they can go to a judge or actually ask you, how do you do it? I want to know if you are infringing my patent or not. You are allowed to say no, I don't want to tell that because it's my secrecy. However, if they go to the judge will order you to at least to show him what you are doing. So at the latest, you have to show to the judge, even if it is your secrecy, so that if there is some, let's say, third party infringement, that might come out. But at least there is no indication, not a direct indication by your own publication. There's no registration process. You don't need to wait so long. You have it the day and you have it. You don't have to wait a long time before doing that. Then that knowledge does not have to be protectable. It is your knowledge, it is what you know, and it remains with you. That is, of course, a good argument for secrecy. Against secrecy, again, you can have some arguments. For example, you will have some loss through diffusion and destruction. So once it is known, it is known, and you cannot undo the knowledge. And you know that actually nowadays, yeah, the lifetime of the highest secrecy is about, I don't know, yeah, 6 months, 7 months. So one time, everybody knows how it works. So it is quite difficult to keep secrets nowadays. Things you have enforcement problems because you don't have any right. You have not an IP right which is enforceable. Then people who have some confidentiality declaration, they might bypass that, and they might actually somehow publish that confidential, let's say, information. Of course, you can go against them, and you can win some against them in a judgment. But again, what you lost is much more than that, because once a thing is known, even if it is known abusively, you cannot undo the knowledge. So it will become clearly very difficult then to claim your right on the secrecy. And then, of course, another argument is, of course, the deposit of property rights by third parties. That means, in fact, if a third party then by himself find the same solution and he asks for the patent, you cannot then claim that it was known, because it was not published by you. So he will actually will have that patent, even if it was your secrecy. So he has the patent, he has the exclusivity, but not you. That is some argument against secrecy. Of course, if you can show afterwards that that was your let's say business secret, then normally judge allows you to keep going in the same amount as before. You cannot make more, you sell more or something like that. You have to actually keep exactly the same amount as before. But so he cannot actually enforce his rights against you if you remain under that limitation. But in any case, he will have exclusivity regarding everybody else and not you. So then another point is actually to find out, for example, which role do I play? Where am I, in fact, in the whole ecosystem? Uh, am I, for example, in a university or research institute? So I'm more on the side of research and development, and that is actually where also the startups and R&D actually startups are beginning. So that is at the level of that. And then if I'm at the level of a large company, so I have to, it is not just having that research and development, I have to produce it, I have to actually to make scale up and so on, I have to solve the manufacturing problems, distribution problems, and of course bring it to market. So just by having the idea, there is no money which is coming back. You have to start from the beginning, of course, by research and development, and then go further and further. So you have to find in that pyramid, where are you actually placed, and to act due to that. So are you on the side of the university? That is the case for most of you. And then once you decided where you are, the technology transfer, the whole process, how can I take it from the research and development, bring it to production, solve the manufacturing problems, to distribution, and then to the market, and make out of it a marketable actually product, which is still not that trivial. So you might actually decide just on the top if you want to keep it secret or to go for patenting, but that might have also huge, let's say, effects for the companies who are interested in that. So you have to keep in mind where you are and try to contact the other parties at the same time, in order to have something in the hand what they can easily use. Might be actually in a situation say actually I can keep it secret, there's no problem. And for the large companies, of course, much more interesting to have a patent, something enforceable. So you could have actually started by the patenting at that time and go to him with the patent, or the vice versa. So that is something which is not, these actually link is not that easy to somehow to bridge. Then one other thing is, in fact, I have an invention, so give me my money, does not work. The whole system is a sort of circle. And once you have uh, these circle fully under control, and you put in place a good circle, then in certain cases you might have a success. So having a good idea, having an invention, it does not mean anything if the rest of it is not done. So you start by the invention, and then in fact the question is about shall or will I disclose that invention. So shall I keep it secret? That is the assessment, keep it secret, or maybe go for an IP right. That means actually I want to do an invention disclosure. So, but before doing that invention disclosure, I do the assessment and then I decide, yes, I will do it. So if I will do it, I will first apply for a patent protection. And during this procedure, there will be actually also the disclosure of the patent. Then once you have that, of course, I hope you learned something from what I said before in the part talking about valuation and strategy, that in fact the marketing part shall even be integrated before the protection part, because you have to know which aspects do you want to protect and so on. So let's, even if it's not done, at least I hope you have the link to go from protection to the marketing. Then maybe finding some interested, let's say, external partners in order to license that. And we are in the case of a technology transfer process from the side of a university. So in fact, your idea is to generate some income by that licensing, by the royalties, and that would be your financial return, which you will again invest in research and development, which might give you another invention, and the whole circle goes around again. So, what I want you to take from these short presentation is that, yes, first of all, we have seen that in Europe, in general, in Switzerland in particular, IP generates lots of jobs. So IP might be a good vector of creating jobs in any country. It's not actually just special for Switzerland, Europe. That is where the study has been done, but I'm sure it works almost in all of the countries. Then the commercialization of IP is multi-structured. So you have to ask the right questions and to answer the question step by step in order to have the right answer. It is nothing which can be done straightforward. It is case by case, and you have to decide in case by case card. Then the knowledge is of course, something you can protect, but that is not a goal by itself. You don't have to register a right. You can keep it secret. It can be your trade secret too. Nobody obliges you to register a patent. And it is even not said that registering a patent is the better way. We showed that there are cases where, in fact, keeping trade secret is much more efficient. So you can keep it secret as well. But make sure that if you keep it secret, it remains secret. Not that you have, with the very first, let's say, part you sell, you will give away the knowledge. So that is what shall be kept in mind. Fourth, as a startup, I should ask myself a lot of basic questions before I start to diffuse my IP. So I start by asking the right questions at different stages. And then I have to find out where am I in the whole pyramid, and then try to find out step by step my way through this jungle of let's say interdisciplinary things where technology on the one side, economy of the other side, and legal aspects on the other side are coming together. So you need, of course, help as a startup. You cannot know everything by yourself. You can start, of course, doing some things from the beginning. And that is also, I would say, some the duty of the technology transfer officers who are hearing me to conduct their startups in the direction. They need the help of a professional in many cases, in the strategical case, in the actually in the decision case, and so on and so forth. And of course, you might still have a lot of questions. Quite understandable. The questions are, of course, welcome. So, what I propose to you is first go through this two further module of that commercialization block. That means actually go in here what I'm going to talk about, let's say, enabling commercialization, let's say, environment, and go and see and hear what I'm talking about, actually, contracts and especially licenses. If there are still questions open, I will give you an example how politics, how the government can also help in a country. I'll just give you the example we experienced in Switzerland, of course, might be actually not directly applicable for you in Peru, but at least that shows that there are ways where politics and the government can help as well. And if at the end of it, if you still have some questions, we will still have some time during the month of August, where we are going to contact in direct, I hope, so that you can ask your questions. I will be happy to answer them if I can, because I'm not, of course, aware of everything. I'm not actually the one who knows everything. So I will answer the question as best as I can, and we will see if it is enough for you or not. Thank you very much, and till soon.